So far, we've spent our time examining what the concept of equity is within the general perspective of equity in trust law. This lesson is going to now move on to the next of these elements, which is, of course, the element of the trust itself. Now, in this lesson, we're going to talk about what a trust actually is, and you'll be surprised to know just how many undergraduate law students go into their law of trusts first lecture, or they may be their first tutorial, and they do not know what a trust is. So this may be helpful to those of you who are just about to start the law of trusts, or for those of you who want to get ahead before you study the law of trusts. So that's what this question is going to this lesson is essentially going to answer the question: what is a trust? What do we mean when we call something a trust? Like I've said, we're moving on away from the study of equity to the subject of the trust. And in fact, the rest of this series is now going to focus on the study of the trust. We're going to talk about the private express trust. We'll talk about the three certainties, the formalities of a trust, the constitution of a trust, charitable trust, etc., 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 etc. We'll examine essentially what a trust is in this lesson, as well as the main considerations for the establishment of a trust, and also the various different parties who are involved in the creation of a trust. The purpose here is for essentially me to go on for the rest of these lessons explaining the various different people and the different titles that exist within a trust relationship, and not have to constantly have to essentially define who these people are. So if I say trustee, you'll know exactly who a trustee is, or a settlor, or a testator, or a beneficiary, for example. So ultimately, the trust is not something which has been particularly very easy to define. We'll get to this in the next lesson when we look at some of the essential elements of a trust itself, because ultimately, owing to the wide variety of different kinds of trusts that exist, as well as the various different purposes for which an individual may establish a trust, it is very difficult to define what a trust actually is. But we can come to some kind of definition, okay? As mentioned previously in previous lessons, the concept of the trust is something which is an invention of the law of equity. It comes out of the concept of equity within the development of the common law. And it was an invention in around the 18th century where, for the most part, landowners would essentially create some kind of protection for the benefit of their future families, some kind of protection of that land for the benefit of future families. And it's from here that we can get to some kind of definition of what a trust ultimately is. Now, a trust is essentially a relationship in law whereby the holder or the owner of some property will be able to transfer the legal title, transfer that ownership to another individual, but not in the sense that they are transferring it because they want to give it to them as a gift, but for that individual to hold said property for the purpose of benefiting a third party, another individual. And that's what a trust is. You are holding property on trust for the benefit of some individual, okay? Now, this property in question, we will get to what the certainty of subject matter actually relates, but it can be a variety of different things. It can be property in the case of land. It could be property in the case of private ownership of property. It could be money. It could be some kind of fund, for example. All of which can constitute the property itself, for which the legal title is being transferred to a trustee for the benefit of some kind of beneficiary. And with that being said, let's think about who the individuals are within a trust relationship. Okay, there are multiple individuals. The person who is the original owner of the legal title, who is going to send that title to another individual, is known as the settlor or the testator. They are the settlor if they are creating the trust before they die. If this is a trust which is created after their death, if it is created post-mortem, for example, then they are known as the testator of that particular property. So if ever I'm talking about the creation of trusts, the settlement of trust properties, and I'm talking about the relationship or the role that is played by a settlor or a testator, you know that that is the individual who is the original owner of the legal title, who is transferring that legal title to another individual, and in doing so creating a trust. The individual who is given this legal title and is told to hold this property on trust for another individual is known as the trustee. Okay, the trustee is the person who is essentially the individual who is responsible for that trust. Whether that may be responsible in the sense that all they have to do is hold on to that property, or they may have even more powers to essentially distribute the property as they see fit in the case of, for example, a discretionary trust. They are the trustee. That is essentially their role. The person who benefits from the trust is called the beneficiary. They benefit from the trust. Okay, so this is what essentially the trust is established for. And that's how we see the relationship of each individual within a trust. We have a settler or a testator who transfers legal title to the trustee, who then holds that property for the benefit of the beneficiary. This is the relationship of a trust system itself. These are the individuals who exist within a trust. Now, in terms of legal and equitable ownership, the settler and the testator, or the testator, has the original legal title. They transfer that legal title to the trustee. But the trustee has to hold that property on trust for the beneficiary, and therefore the beneficiary has equitable rights to that property. So they have rights in equity. And what this essentially does is split what is legal and equitable interests in the same property, because ultimately the trustee holds the legal title of that property and the beneficiary will hold the equitable title or equitable rights in that property. And so what a settler or a testator is doing in creating a trust instrument is dividing the legal and equitable rights over a piece of property between a trustee and a beneficiary. Now, we're going to talk in a little bit more detail about defining trusts in the next lesson, talk about some more of the characteristics of a trust, but we'll also then start to talk about the various different kinds of trusts that exist, whether they be implied resulting trusts, constructive trusts, discretionary trusts, for example, and then we will from there start to talk about the first of our trusts that we're going to explore in more detail, which of course is the private express trusts and the formalities that are required to establish them. So we introduced the next major topic in our series on equity and trust by asking the question in the previous lesson, what actually is a trust itself? And we looked at the various different elements of a trust. We looked at the various different people who participate in the trust, i.e. the settler and the testator, and then we have the trustee, and then we have the beneficiaries. This lesson is going to talk a little bit more about the elements of a trust, the nature of the trust itself, talking a little bit about the difficulty in coming up with a definition of a trust, owing to the clear variation in terms of the amount of different kinds of trust that exists, as well as the different rationales for even having a trust in the first place. And then we will finish by talking about the influence and the impact of equity in this particular conversation. Because one of the things that you might be asking is, I understand what the trust is. I understand what we mean when we talk about the idea of the trust, the holding property on trust for a beneficiary, etc., etc., etc. But where does the idea of equity come into it? You've spoken about how important equity is and how equity is an invention or invented the concept of the trust. Where does all of this factor in? This is what we'll explore in this lesson. So the fundamental building blocks of the trust is going to be what we are looking at in this lesson. Examining the types of trust that exist in English law will be the next lesson. So talking about the distinction between an express trust, for example, and the types of implied trust that exist, the concept of a secret trust, discretionary trust, etc., etc., etc. All of that will be the next lesson. So let's think then about the characteristics, the fundamental characteristics of the trust itself. Given the wide range of different kinds of trust that exist, which is something that we'll explore in the next lesson, bear in mind the next lesson is going to talk about the different types of trust, but only the main types of trust. There are many, 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 many different kinds of trust that exists in this area. But given the wide range of different kinds of trusts, and given the wide variety of purposes for the existence of a trust, the idea of coming up with a key definition is something of a futile attempt. So it's something of an impossible task that we are looking to. But with that being said, even though it is impossible, essentially, to come up with a defined, concise definition of what a trust is. Hence why it has been very difficult for a number of authors to try and come up with some kind of definition of a trust. Hence why it is also difficult for law students to understand what a trust is. There are some certain number of elements which are something of a universality when it comes to the application to trusts. So, for example, the concept of the trust and their use has a general theme in terms of their rationale. The general purpose of a trust, whatever kind of type the trust may be and whatever rationale exists, it tends to involve the protection of some kind of property in some way, doing something with some kind of property. Now, you might be thinking, well, that's a particularly broad, nigh on meaningless characteristic, and because of how broad it is, and you'd be probably correct that one of the universal elements of a trust is the fact that it is doing something with some kind of property, or it is trying to protect some kind of property in some way. It is essentially a meaningless statement, but this is why the definition of a trust is so futile, because the idea of a trust is such a broad conceptualization that it makes it very difficult to come up with any kind of definition. A trust also tends to entail the transfer of legal title for a particular purpose. So this is another characteristic that tends to exist when it comes to a trust. The trustee will have access to this legal title, but there is often a limitation on what they can do with it. Now, this is something that is depending on the type of trust, because depending on the type of trust will depend on the amount of authority that a trustee may have over the legal title to some property. So, for example, in certain trusts, for example, in a discretionary trust, there is actually quite a lot of power that a trustee may have, because they may be able to distribute the property among the various beneficiaries at their own discretion. Hence why we get the idea of a discretionary trust in that regard. But ultimately, the characteristics of a trust entail that there is the transfer of some kind of legal title. There is the transfer of title to some other individual, and that this is not just a gift. This is not just giving that legal title to another person, but it is the transfer of legal title for a particular purpose, for that individual to hold that property on trust for some reason. So this distinguishes a trust from a simple gift, for example. When a settler or a testator is transferring legal title to a trustee, they're not giving it to them. Okay, they're not giving it to them as a gift to do with whatever they so choose. They are not doing it for the trustee to essentially just enjoy. They're giving it to them for a particular purpose, to hold and to manage that property in that kind of way. This relationship gives us some ideas about a potentially unified definition of a trust, or at least a potentially unified set of characteristics about a trust. So, for example, a trustee is given assets which do not form part of their own estate. So when a trustee is given assets to hold on trust, that property is separate from the rest of their ownership. Okay, it doesn't just merge into the rest of the things that they own as something that is theirs. It is something that is distinct and separate because it is held on trust. They have a duty to manage said assets. Now, depending on the type of trust they have, will depend on the amount of work that is involved in doing so. Some people just are trustees and they just hold the property, and it is up to the beneficiary to essentially essentially liquidate the trust whenever they so choose, and to receive the benefits of that property whenever they want. But in some cases, the trustee actually has quite a lot of authority and quite a lot of power to hold, to manage, and to distribute the property that has been held on trust by the settler or the testator. The trustee also has a number of powers relating to the management, the employment, the disposal of said assets. These powers are often outlined under the terms of a trust. So when we talk about a trust being created, it is often created by deed, by contract, by some kind of oral agreement, and there will often be a number of different terms within the characteristics of the trust instrument to essentially outline what powers and authority the particular trustee has over the property that is being held on trust. But as mentioned, there are a wide range of different types and purposes for the use of a trust. A trust may be expressly made, or it may be implied through a multitude of different systems. We can have a resulting trust or a constructive trust in terms of the ways in which trusts can be implied. Individual may create a trust during their life, i.e. they may create it as a settler, or they may create it, or it may be created, should I say, after their death, in which case they are the testator. So all of these different things find our way to looking at a conceptual definition of a trust, rather than trying to find a specific definition that we can just wheel out whenever we want to. It's better to have a conceptual understanding of what the trust is for us to then move forward in talking about the way trusts are created, the various certainties, the various formalities, and the various constitutions of trusts. Finally then, where does equity factor into all of this? So, as I mentioned earlier at the start of this lesson, equity created the trust. The trust is potentially equity's greatest invention. And we've spent a lot of our earlier lessons talking about what equity is and the history of equity and how equity is delineated from that of the common law with the Court of Chancery, etc., etc., etc. So where does equity factor into this story, this concept? Well, the idea here is that there are equitable obligations that exist between the trustee and the beneficiary. Or even, you could argue that there are equitable obligations that exist between the settler or the testator and the beneficiary. The settler and the testator will transfer legal title to the trustee, and the trustee will hold that legal property on trust in equity for the beneficiary. And so the result is that you see a splitting of legal and equitable interest and equitable rights. The beneficiary has equitable rights over that property, but the trustee holds the legal title and holds that property on trust. According to Parkinson, the notion of the trust lies in the notion of equitable obligations in relation to property, which in most cases will also give beneficiaries commensurate property rights in equity. So the beneficiaries aren't just sat there and the trustee can do whatever they want with the property. The beneficiaries have certain rights over that property, but they don't have legal rights because the legal title has been transferred by the settler or the testator to the trustee. So therefore they must have equitable obligations, equitable rights, should I say, and equitable obligations. So that's why, as Parkinson states, most cases it will involve the beneficiaries having commensurate property rights in equity. What I want to do in this lesson is start to talk about the different types of trust that exist within the law of equity and trusts. And the purpose of this lesson is to really give a basic outline of each of these different elements of the different kinds of trusts in order for us to then start to examine these in far more detail in future lessons' time. And we'll begin with the express trust as the one that to focus on for the first set of lessons in the third chapter of this series. But we will also talk about other trusts that we may or may not spend too much time examining. And I should also make it very clear that while this is going to be quite a long list of different types of trusts that we're exploring in this lesson, this isn't an exhaustive list. There are other types of trust that can exist, some of which we will explore as well in the future. So just bear that in mind. So like I said, we're concerning ourselves with the different kinds of trust, the different types of trust that we'll be spending the majority of our time looking at in future lessons' time, looking at the substantive law attached to them. Now, the idea here is, like I've said, to provide a nice basic overview of the different kinds of trust that you may study in your time doing the law of trusts. Now, depending on which university you go to, which module you take on equity and trusts, it will actually depend on the different types of trust that you explore. Pretty much every university module will explore things like the express trust, the discretionary trust, but some may or may not talk about the idea of trusts for charitable purposes or secret trusts and things like that. So we'll be trying to be as broad and all-encompassing as possible while also being reticent to the fact that there are some trusts that deserve and merit more attention than others. And one such example of this is the idea of the express trust being the first place that we're going to start. So as you can imagine, and as the title suggests, in the name, an express trust. An express trust is created expressly, and by way of being expressly created, it is done either through a deed, or maybe through contract, or maybe through some kind of oral agreement, or even a will. And essentially what happens here is a settlor or a testator will define a third party to be a trustee. Often it is a third party. You don't often, or you can have situations where they are the same individual, but for the most part they are not. So a settlor or a testator will define a third party to be a trustee. They will then also define a beneficiary, and then they will also define the property to be put on trust, and all the other various intricacies in relation to some kind of trust agreement, i.e. the kind of powers that are going to be granted to the trustee specifically. Like I said here, it is created expressly, which means it's either created through some kind of deed, a will, a contract, or maybe even an oral agreement. And the main requirements that pertain to the creation of an express trust relates to what are known as the three certainties. Now, this is what we're going to spend the majority of our time in the next chapter on this topic looking at three certainties. But for now, as a basic overview, there has to be a certainty of intention, there has to be a certainty of objects, and there has to be a certainty of subject matter. These are the three certainties which are the requirements which must be satisfied in order to establish an express trust. The bare trust is similar to that of an express trust, but the idea of a bare trust versus the idea of a discretionary trust relates more to the powers and authorities and the duties that are imposed onto the trustee. It is a very simple kind of trust, and it can be created expressly. Essentially what happens here is the trustee will have no duty but to hold onto the property on trust for the beneficiary. So what this essentially tells us is there are some instances where there may be a trust agreement that is established, where the settlor or the testator creates the trust, puts the legal title on trust to the trustee, and gives a lot of authority and maybe a lot of power and duty to that trustee to manage, operate, and to hold those assets on trust for the purposes of the beneficiary. With a bare trust, this is not the case. The only authority that the trustee has in the case of a bare trust is to hold the property on trust. That is all that they can do, because ultimately what then happens is they will hold the property on trust, and they will do very little else until the beneficiary decides that they want to conveyance the property and take over the legal ownership of it. The beneficiary is therefore almost the de facto owner, since they're able to essentially obtain it at any time without any kind of delay. Now, the idea here is to essentially ensure that maybe the beneficiary doesn't want or need or has not come of age to be able to conveyance the property at a particular time, and so as a result of which the trustee just holds that property for them until the time they see fit is reached, at which point the beneficiary then decides to conveyance the property and become the owner of that property, and to essentially alleviate the role of the trustee in that particular environment. An executed trust is one where you have an agreement. Again, you have a settlor and a testator that is putting property on trust for the trustee for the benefit of the beneficiaries. But rather than a bare trust, in which essentially it gives authority to the beneficiaries to decide when to conveyance that property, it's actually the settlor or the testator that gives clear direction as to the transfer of the legal title to any of the beneficiaries. So they give the clear instructions to the trustees about what to do with that property. So, for example, if an individual makes it very clear that when they die, their £10,000 trust property will be divided into two, 50-50, and will be given to two specific charities. Okay, let's say they're given to the RSPCA and cancer research. Okay. This is considered to be an executed trust, because what is happening here is the settlor or the testator has put that property on trust, the £10,000 assets, and they have given a very clear direction to the trustee that at which point when they die, or at any other point in time or whatever, you are to do this thing with the property. You are to transfer it, you're supposed to divide it specifically into two and give it to these two specific charities, okay? That is how it is described as an executed trust. There is more power that is given to the trustee in a way, but there's almost less power at the same time, in the sense that they are doing more things with the property, but they are under strict instructions from the settler or the testator to essentially distribute the property in a way that they wanted to have distributed at whatever point in time they wanted it to do. So here the beneficiaries will be clearly defined, the benefits to each of the beneficiaries would be clearly defined, and they are all clearly defined by the settler or the testator. Now, a discretionary trust gives a trustee a lot more authority, because what a discretionary trust will do is give the trustee a certain amount of power in relation to how they will decide what to do with the trust property. So they will hold that property on trust, and they maybe have to, in the trust agreement, there may be some kind of clause or a provision which says that you hold this property on trust, and at whichever point you may see fit, you can then distribute that property to the beneficiaries. Or even you may say there may be an agreement which says you are holding that property on trust, and the trustee, at the point at which the settler dies, will then distribute the property which is held on trust as they see fit, which may also regard essentially how they are going to distribute that property up. Does it have to be distributed completely and equally across all of the beneficiaries? Will it be distributed not in an equal manner? And depending on how many beneficiaries there are compared to how much property there is to divide up, can depend on whether or not a court may judge it to be the case that you divided equally versus divided it in a non-equal way. Ultimately, in which case the settler or the testator may specify to the beneficiaries, but they may not necessarily specify how the property will ultimately be divided and what is the ultimate end goal or the end result of where that property is going to go. That may be something that is the discretion of the beneficiaries. A less important, but still one that we might touch on in future lessons' time, the idea of the secret trust is quite easy. A secret trust will often be created on the death of the settler, since they will often include the establishment of the trust within their will, and so as a result of which it is sort of part of a general set of rules and principles relating to the law of succession. And there are two main kinds of secret trust that can exist. There is the idea of one which is fully secret. This is where there is no actual evidence on the face of it that the trust is even created by the will of the settler. Upon a close examination of the will, there may not be any evidence that the trust is even established. You may also have a half-secret trust. This is where the trust creation can be established by the will. We can see that a trust is established upon the terms of the will, but maybe the beneficiary is unknown. And so as a result of which it is considered to be a half-secret trust. The fully secret trust suggests that there is no evidence of the trust in the first place, but a half-secret trust accepts that there may be evidence of the trust, but maybe no evidence of who the beneficiary may be. Finally, then, let's look at the ways in which we can find implied trusts. Trusts which are implied through various different circumstances. Now, a trust may be implied in one of two ways. They may be implied as a resulting trust, or they may be implied as a constructive trust. These are the two different kinds of implied trust that can exist. When we look at a resulting trust, essentially a resulting trust may arise where there is some title or maybe some property which is held by one person in law, like legally held, but that the true owner of all of that property, or maybe even just part of that property, is another individual on the basis of their contribution to it. The most important examples that we often see here is in the relationship between owners of land and the purchase of land. So, for example, if two people were to contribute to the asking price of a new house, and the house was only in the name of one of the individuals, so legally the ownership was only in the part of one person, but that the two people together contributed significant sums to the asking price, then a resulting trust may arise owing to that contribution that is made. So the fact that there is a contribution that is made by the other person means that even though they are not legally are maybe legally owners of that property, there is an implied trust that exists in relationship to their ownership, owing to the fact that they have made a significant contribution. Finally, then, a constructive trust is one which may be imposed by a court owing to the interference of property in some way. One such example of this will be through the use of, or through the existence of, unjust enrichment and the sort of general restitution that exists as a result of that particular area of the law. We will get on to constructive trust in more detail, but one thing to note is that a constructive trust in this regard, therefore, exists as a kind of remedy to some kind of potential interference in property. And I've used the example here of an unjust enrichment. And so a constructive trust may exist as a remedy to unjust enrichment. In this final lesson, examining the basic concept of the trust, what we're going to do is make a clear delineation between the idea of a power and the idea of a trust. And this gets us into a little bit of the details relating to some of the different kinds of trust that can exist, or at least some of the kinds of trust that exist on the basis of the kinds of authority that are given to a trustee, who is then going to essentially deal with the property which is being held on trust for the beneficiary. But then afterwards, we're going to start to talk about the creation of the express trust, namely looking at the three certainties and looking at the different ways in which the three certainties apply to either this idea of a fixed trust or a discretionary trust. So essentially in this lesson, we're going to spend some time examining the delineation that is made between the use of a discretionary trust and the idea of a power. And the reason why this is important is because sometimes you can look at a trust instrument, or you may be able to look at a problem question, and you might struggle to clearly delineate between what a discretionary trust is and what a power is. And so the point here is to have a look at this in more detail. So there are a lot of similarities which are had between the idea of the discretionary trust and certain powers which can exist in relation to a property which is being held on trust. Okay, so it's not all powers, of course, but in certain circumstances you can have a look at see a trust power that is very similar to just the idea of a discretionary trust. So the key delineation here is, of course, this idea between a discretionary trust and the idea of the power of appointment. And the reason why there are a number of similarities is because, for example, in both instances, there is the ability for the individual in question, i.e. the person who is in charge of the property, who takes legal title of the property, to essentially distribute assets to beneficiaries. So one of the things that we know when we talk about the law of trusts, at least in the creation of the express trust, is that you will have a settlor or a testator who will then transfer legal title to the trustee, which is sometimes known as having proper constitution, which we will get to in a future topic. They go to the trustee then holds that property on trust and has legal title to it, whereas the beneficiary has equitable rights in that property. And of course it is the trustee who holds that property on trust for the beneficiary. And in a discretionary trust, and in some circumstances when we talk about the powers of appointment, there are similar key similarities in terms of the ability for a trustee to be able to distribute assets to a beneficiary. What then are the key differences between trusts and powers? Well, when we talk about a discretionary trust and the delineation and distinction that is had to the idea of, for example, the power of appointment, when it comes to the discretionary trust, the idea of distributing assets to the trustee, to the beneficiary, should I say, in terms of property, is an obligation. Okay, it is a requirement for a trustee to distribute the property given in the prescribed discretion. So essentially, what a discretionary trust does is give the trustee a certain amount of power in terms of, or at least a certain amount of authority in terms of their ability to distribute assets, and they may be able to distribute assets to at their own discretion. but the requirement to distribute the assets is not one that they have any kind of say over. They have to distribute the assets, but they may be given discretion over how to distribute the assets. For example, maybe the settlor or the testator holds the property on trust. Let's say that's a lot of money that they hold on trust. They give this to the trustee and they make a big old list of beneficiaries. And let's say the beneficiaries are a number of charities, 3 or 4 charities, okay? And they say you can distribute this property to these charities in whatever way you see fit, and the trustee may then have the discretion to go ahead and distribute some to this charity, maybe a little bit more to that charity, maybe a little less to that charity, etc., etc., etc. But the question here is, in a discretionary trust, there is an obligation to do that. There might be a prescribed amount of discretion in doing so, but the actual requirement to do it versus not to do it in a Shakespearean manner is actually to essentially you have an obligation to do so. When it comes to a power of appointment, this same obligation may not be present. And it means that if you have a power of appointment which is not exercised, essentially what happens is you have a default of the appointment, at which point the property goes back to the original ownership. A further distinction between trusts and powers is this idea of there existing some kind of fiduciary relationship. A fiduciary relationship, for those of you who are unfamiliar with the key terminology, is simply a relationship of trust. It is one of trust. So you can have fiduciary relationships that exist in all kinds of circumstances. A company director may have a fiduciary relationship to the company's shareholders. A solicitor may have a fiduciary relationship with their clients. The concept of a fiduciary relationship, however, also arises in the case of a trust, namely between the trustee and the beneficiary of the trust. What happens there is you have a trustee who holds the property that has legal title, that has equitable, and the equitable rights exist in the process of the beneficiary. And of course, the trustee has a fiduciary relationship and a fiduciary obligation towards the beneficiary in some way. When it comes to powers, this kind of relationship may be fiduciary, so you can have powers of appointment which have fiduciary attachments to them, but you could also have ones which are just simply personal relationships in nature. And so let's just finish on a case which illustrates some of these points in a little bit more detail. The idea of the case of Metoy Pension Trustees from 1991. In this case, we have a certain pension fund scheme where essentially if there was an additional surplus of funds in the corporation, this could be applied at the discretion of the employer. So the employer has a certain amount of discretion, and essentially what happens here is the discretion that exists is this idea that if there is additional surplus, you have the discretion to do with that what you see fit. When the company then went into liquidation, the benefits from this surplus stood at a hefty £9 million, so quite a significant amount of money. And what the issues were that the court had to consider were twofold. The first question that the court had to consider was whether or not the beneficiaries were entitled to discretion, i.e. whether or not the power was a fiduciary power, whether or not it had some kind of fiduciary relationship. And then the second question is whether or not the exercise of the power can be done by a liquidator in the process of insolvency. We won't get into the concept of insolvency law in this lesson, but essentially one of the things that happens when we have the winding up of a corporation, whether that be voluntarily or through court discretion, you may have a situation where a liquidator then goes about distributing assets to creditors in the way that they see fit. And there's lots of different rules, lots of different principles that relate to that. But the question here was, could this power of discretion to distribute these assets be done by the liquidator in the process of insolvency? And it was held that in answering the first question, the power was fiduciary, so the beneficiaries had discretionary rights to that property. In answering the second question, it was held that the liquidator actually had no authority to exercise the power since the assets were not held by the company. They were held by a pension, under a pension scheme held on trust. However, the power was therefore able to be enforced by the court.